if I could talk to State Farm about not having the water shut off at the building. And I explained to her that, State Farm has nothing to do with that. You'd have to talk to either the water department, because she commented they wanted to do some cleanup and they were going to need to have water. And, I told her, I said, State Farm doesn't have anything to do with that. Check with the water department or the village. And I think she had talked to the village. I don't know what about. But I don't really have recollection of much else that she specifically called about that water issue. And I know that was the mom, and that's why I was thinking the daughter had called me before. But I don't know either of the first names.
And approximately when was that?
When she called me?
Yeah, that conversation.
It had to be later because the daughter had called me first based on my inquiry to see if there's any chance that property might be available for rent for that other person. I got that happened first, and then Mrs. McShirley, when she called me, I don't know if that was in June or July. I really don't know, and I don't have any record of it. I just remember that she called.
Of our rights, Jeff Landry, Swanton, Ohio.
Did you ask whether or not the claim had been denied?
This is a scam.
No, she didn't. But it's funny you bring that up, because the day she called me about that water, she said, I heard the claim was denied. And I said, really? I don't think I knew that at that point in time. I didn't know the claim was denied until Lonnie, who was the claim rep, called just to let me know, Jeff, I just want you to be aware that claim was denied. But he didn't give me any specifics. I've never seen the denial letter. I'm not sure why it was denied. But yeah, she did. I found it odd that she knew that, because I have no idea who she heard it from.
Okay. And is it typical for you to not hear whether claims get approved or denied, or is that something that you follow up with?
Well, I don't follow up with it, but it's pretty rare things are denied. I've been an agent 35 years, and I can probably count on one hand, cases that might have been denied, probably not even all 5 fingers. So yeah, it's pretty rare, but so I don't know what the protocol is, other than I know Lonnie called me just to let me know, but he didn't get into any details, and that, I don't think they don't get into that stuff with the agents. They don't share that stuff.
Oh boy, here we go.
Right.
Come on, Zach.
So they don't share that stuff with the agents. You categorize Miss McSorley as finding it odd that she had that information. Obviously, you don't know where she got that information, but typically, is there any way for the public to find out a claim was denied?
Not that I'm aware of.
Okay.
Not that I'm aware of.
So it would have to come from somebody with knowledge, or within the insurance company.
Either that, or maybe she was fishing. I don't really know. I mean, I have no idea. But I found it odd that she asked me that.
Well, good evening, good evening, good evening. Thank you for joining us tonight. We are going to go over the most recent filed exhibit in the Supreme Court of Ohio, case number 2025-1257. You can go to the Supreme Court of Ohio and you can look at the docketed information. This will not reflect on the docket, obviously, until Monday, when the Supreme Court is open, but obviously anytime we file something and we serve the other party, we do bring it to all of our platforms so that everybody is informed with any and everything that we do. That's why we built these platforms, so that we can share when there's been any type of action in the court, because these mainstream scamified news media, news stations and all that, they don't want to cover this and they don't want to cover that unless somebody is implicated as a criminal where they can make money off of making somebody look bad. That's when they want to cover something. But when there is, an injustice involving a company that's doing completely nothing but violating someone's civil rights, they don't want to cover it. So we had to take our case all the way to the Supreme Court, and this is exhibit number 68. As I said before, you can go to the Supreme Court of Ohio and read all of the exhibits and all of the evidence as to what we are asking the court to do in regards to the mistreatment of State Farm Fire and Casualty Company. So please like, share, comment. Don't forget to subscribe. If you choose to support us, you can do so by utilizing our cash tag at DonateKNSMIN. So as you can see here, this is the exhibit that was filed in the Supreme Court today. I'm going to go ahead and start going over this with you guys so you can really see it for your own self, what it is that State Farm did. And we're going to keep on beating that drum until they're held accountable. In the Supreme Court of Ohio, Marquise L. Kimble versus State Farm Fire and Casualty Company, case number 2025-1257. Exhibit 68A, legal analysis of State Farm's fraud narrative, investigation bias, and claim handling violations. Introduction and purpose. This exhibit 68A is submitted to the Supreme Court of Ohio to analyze the legal violations evidenced in State Farm Fire and Casualty Company's trial brief. So this is something we're looking at, one of the past trial briefs that these guys scamified filed in Fulton County Court, and we're going to provide an answer. And this is what this is detailing. As filed in Fulton County Court of Common Pleas, case number 22CV000180. And as it pertains to Minister Marquise L. Kimble. The trial brief represents State Farm's official litigation position that not only denied coverage, but did so by advancing claims of fraud, concealment, and misrepresentation by Minister Kimble and HCV Distribution Corporation. This filing demonstrates and reinforces State Farm's pattern of outcome-oriented, adjusting, racially biased investigation and ongoing reputational harm targeted a Black pastor and a Black-owned business. Highlighted violations by State Farm Fire and Casualty Company, bad faith and unfair claim settlement practices, legal framework, Ohio Common Law and OAC 3901-1-54, ORC 3901.21 require insurance companies to handle claims in good faith, conduct thorough, unbiased investigations, and not delay or deny claims without reasonable justification. Violations identified. State Farm's brief states outright that it denied Kimble's claim due to alleged misrepresentations, fraud by Kimble, including misrepresenting loss amount, concealing financial conditions, and procuring someone to cause the subject theft, vandalism, and water loss. In the face of extensive documentation of a real crime and failure of local police to timely respond, the Swanton Police Report 000023-22, that's covered in Exhibit 66A. State Farm ignored explanatory facts and instead focused entirely on painting Kimble as guilty. State Farm failed to contact, interview key third parties, including witnesses to alternative motives, the McSorley Trust, Ballas McNeil Chevrolet, individuals involved in related harassment or impersonation events, the Swanton PD regarding their delayed response and investigative bias. The investigation ignored mounting evidence of retaliatory, racially motivated hostility against Kimble, thus denying coverage arbitrarily and capriciously. Defamation and defamation per se. Publicly accusing a business professional and minister of fraudulent claims, staging a crime, and intentionally misrepresenting material facts constitutes defamation per se under Ohio law, especially when such accusations are made in public court filings and pleadings. Violations identified. State Farm used its court filing to assert multiple direct accusations of fraud against Minister Kimble, in contradiction to the police report, documenting him as the crime victim, not a suspect or a perpetrator. These actions have caused irreparable reputational harm to Minister Kimble, his business, and his standing as a faith leader in the community. Accusations stated as fact in official litigation, when a reasonable and fair investigation would have revealed grounds for Kimble's innocence, created liability for defamation, especially when amplified in a high-profile racially charged case. Misrepresentation and outcome-oriented investigation. Insurance claim investigations must be fair, objective, and consider all relevant facts. Outcome-driven processes that pre-assume guilt or fraud while disregarding explanatory evidence or failing to consider alternative explanations, such as a third-party motive or police negligence. Violate industry standards of good faith and statutory requirements. Violations identified. State Farm ignored or omitted facts of a third-party misconduct, including police and landlord negligence, telecommunications harassment. That was done by the former McNeil Chevrolet, contacting me, impersonating Swanton Police Department, documented in a police report, Exhibit 67. Intimidation and impersonation by local actors. Witness list in the trial brief omits individuals connected to documented third-party retaliation, focusing instead on sources and documents only supportive of State Farm's fraud narrative. State Farm's selective use of police reports, video, and business records was not to fairly adjudicate claim validity, but to construct a one-sided case against Minister Kimble and HCV Distribution Corporation. Violation of insured civil rights. Disparate, harsher treatment of Black claimants and business owners, especially when the original loss involved a racially motivated hate crime. They spray painted the word nigger on my walls. That's what they did to our business. Do you need to know if that was a hate crime or not? And there is documented failure by police to respond with equal urgency. I guarantee you if McNeil Chevrolet's store alarms went off in the same town and they're further away from the police, it would not have taken the Swanton police an hour to respond. You're going to tell me we were located 0.2 miles from the police station and it takes them an hour to respond to a hate crime when they're notified by the alarms? I wasn't born yesterday, you scams. Implicates both insurance, civil rights obligations, and broader public policy concerns. Violations identified. The context for State Farm's actions is a racially motivated attack on a Black-owned business with demonstrated police indifference. State Farm's refusal to acknowledge this context or to interrogate alternate sources supported a discriminatory claim outcome. Details of how each violation supports the overall misconduct narrative. State Farm's entire litigation and claim posture, as reflected in the trial brief, was built to deny, defame, and delegitimize Minister Kimble and HCV Distribution Corporation, disregarding objective contrary evidence. Failure to investigate alternative causes, refusal to document third-party misconduct, and exclusive focus on painting Kimble as a fraud reveals a systematic pattern of outcome-driven, unfair, and biased adjusting and litigation. The layering of denial, defamation, and lack of due diligence in the broader context of racially motivated hate crime and policy vulnerability constitutes not only bad faith, but an egregious breach of public trust for Ohio's largest insurance carrier. Integration with previous exhibits and litigation history. Exhibit 68 and 68A directly integrates with Exhibit 63 through 67A as part of Minister Kimble's and HCV Distribution's broader complaint. Compounds violations shown in Exhibit 68, Swanton Police Department delay, victim mislabeling. Exhibit 65A, landlord conversion and lockout. And Exhibit 67A, telecommunications harassment and impersonation of the Swanton Police Department. Confirms State Farm's procedural and strategic pattern, disregard of factual truth, one-sided investigation, willingness to make and repeat defamatory allegations, and misuse of claims process for adverse economic, reputational, and emotional impact. Legal relief sought. Minister Marquise L. Kimble respectfully requests that the Supreme Court of Ohio find that State Farm Fire and Casualty Company's handling of his claim and subsequent litigation were conducted in bad faith and in violation of Ohio insurance law and defamation law. Issue sanctions, punitive damages, and systematic remedies that will deter further use of such outcome-driven, reputation-destructive practices against vulnerable communities. Consider the pattern documented in Exhibit 63A through 68A as warranting extraordinary relief, oversight, and full vindication for Minister Kimble and HCV Distribution Corporation. I hereby certify that a true and accurate copy of this exhibit was served electronically upon counsel for respondent State Farm Fire and Casualty Company on this 22nd day of November. And that, my friends, concludes the exhibit that was filed with the court today. You can log into the Supreme Court. You can look at all of the evidence. These scams are not going to get out of this. We are going to do everything in our power to hold them accountable. Please like, share, comment. Don't forget to subscribe.